You write an article, you make a video, you publish a newsletter. Someone asks Perplexity a question, and Perplexity summarizes your work, gives the user the answer, and keeps the traffic. You get nothing, not a click, not a subscriber, not a cent. The New York Times filed a federal lawsuit against Perplexity AI in December 2025. Perplexity filed a motion to dismiss, and most of the coverage has treated this as a he said, she said between a legacy publisher and an AI startup. But it isn't. Perplexity's legal defense should fail. And the reason why has direct consequences for every creator whose content is being used to power AI products they never agreed to. I'm going to explain exactly why, using an argument most coverage isn't even making. Nothing in this video is legal advice. It's legal commentary. If you need legal advice, speak with a lawyer in your area. With that being said, I'm Stevie. This is Girl Code of Law. Let's get into it. Let's establish exactly what Perplexity does, because the legal argument turns entirely on the mechanics. Perplexity is an AI-powered search engine backed by Amazon founder Jeff Bezos. You ask a question. Instead of returning links like Google does, Perplexity generates a written answer using a technique called Retrieval Augmented Generation, or RAG. It crawls websites in real time, retrieves their content, and synthesizes a direct response. Here is why that's legally different from Google. When Google returns search results, users click through to the source. The publisher gets the traffic, the ad revenue, the subscriber. With Perplexity, the answer is the destination. Users never visit the source. The publisher of the original content gets nothing. The New York Times alleged in their complaint that Perplexity's outputs were verbatim or near verbatim reproductions of their reporting, not paraphrasing, not summaries, direct copying. They also alleged something more damaging. Perplexity was generating false information and then attributing it to the New York Times, using the paper's registered trademark to vouch for content that Perplexity had fabricated. Perplexity's response was to file a motion to dismiss. Their argument was that they cannot be held liable for infringing content that appears based on users' prompts. The user asks a question, the user drove the infringement, it's not Perplexity's fault. That defense sounds reasonable perhaps on the surface, but it isn't. And the reason why is grounded in copyright doctrine that predates AI by decades. Under the Copyright Act, 17 U.S.C. Section 106, a copyright holder has 6 exclusive rights. One of them is the exclusive right to prepare derivative works based on the original, which means the only person who can legally create a new work derived from an original copyrighted work is the copyrighted holder or someone the copyright holder gave a license to. When Perplexity uses RAG to retrieve your article and synthesize its answer, it is creating a new work derived from your original expression. That is a derivative work. It doesn't matter that the output is shorter. It doesn't matter that it's in a different form. What matters is that it is substantially derived from your copyrighted original content, and it substitutes for the commercial purpose of the content in the marketplace. The second element is the market substitution, where Perplexity's fair use defense collapses. Fair use has a 4-factor test. The 4th factor, the effect on the market for the original work, is the one courts weigh most heavily. The U.S. Copyright Office itself identified RAG systems as potentially reproducing copyrighted materials in outputs in its May 2025 report on generative AI. The market harm Perplexity causes is not theoretical. A user who gets the answer from Perplexity does not visit the New York Times. It doesn't click a creator's link, and it does not subscribe. The commercial purpose of the original content, driving traffic, building audience, generating revenue, is directly replaced by the Perplexity output. That is textbook 4th factor failure of the fair use doctrine. The Thomson Reuters v. Ross intelligence ruling in February 2025 established this principle in the AI context specifically. A court found fair use failed because the AI system's output competed directly with the original product in the same market. Perplexity's AI summaries compete directly with the journalism that they're summarizing. And Perplexity's volitional conduct defense that the user prompted the response does not survive contact with the derivative work's analysis. The derivative work is created by Perplexity's system. The user typed the question, Perplexity's AI retrieved the content, processed the content, and generated the derivative output. That is Perplexity's conduct, not the user's. The derivative works argument is the strongest legal theory in this case, but the false attribution allegation sitting on top of what makes Perplexity's position genuinely difficult to defend. The Times alleged that Perplexity was generating fabricated information, content the New York Times never even published, and displaying it alongside the Times' registered trademarks and branding. Under the Lanham Act, Section 43A, that is false designation of origin. It creates consumer confusion about whether the New York Times endorsed or produced that content. It is a separate federal violation on top of the copyright claim. For creators, this second claim is arguably more dangerous than the first. Copyright infringement requires proving your work was copied. False attribution requires proving your brand was used to vouch for something you never said. The harm to your credibility happens the moment the false content circulates attached to your name, which is often before a creator even knows that it exists. A creator with 100,000 subscribers who has spent years building trust with their audience has exactly the same exposure as the New York Times on this false attribution claim, but the scale of the brand is different. The legal theory, however, is identical. And unlike copyright, which requires registration for full statutory damages, Lanham Act claims are available to anyone whose brand has commercial recognition. Here's what this means for creators. If the New York Times wins on the derivative works theory and based on the Thomson Reuters precedent and the fourth factor analysis, the legal argument is strong. It establishes that AI search engines cannot create commercial substitutes for creator content without licensing it. That is a structurally significant win for anyone who makes content. It means RAG-based summarization of your work requires a license. It means compensation frameworks become legally necessary, not just commercially desirable. This case is being fought by the New York Times, one of the most resourced media organizations in the world. The precedent they establish applies to your content, to every content creator. But the licensing deals they negotiate will be for institutions like New York Times, not independent creators. Being in the same legal category as the Times doesn't mean being at the same negotiating table. What it does mean is that the legal foundation for creator rights against AI scraping is being built right now. The derivative works argument, the market substitution argument, the false attribution claims, these are the tools in the toolkit. The Chicago Tribune filed the same week as the Times. Dow Jones and the Wall Street Journal sued Perplexity in 2024. There are more than 40 AI copyright cases in the U.S. right now. This is a legal campaign being waged incrementally across dozens of different cases. The creators who will benefit most from this legal campaign are the ones who understand the legal theory, document their original works, and are positioned to act when the precedent lands, when these cases are settled, not after it's set and the licensing frameworks are already built out around institutional players. Here's the position I'm taking on this case. Perplexity's defense is likely to fail because it mischaracterizes what its system actually does. It doesn't just retrieve, it creates. What it creates is a derivative work that commercially substitutes for the original work. That is not a fair use. That is not transformative. It is undermining the commercial market of the original work. That is the exclusive right of the copyright holder being exercised by someone else without a license. The New York Times is the one fighting this in court, but the content being scraped, summarized, and substitutes belongs to every creator who publishes anything online. This case is being decided for all of us. If this was useful, share it with another creator in your circle and subscribe, because I am tracking exactly how this develops and what it means when the ruling lands. I'm Stevie. This is Girl Code of Law. I'll see you next time.